In the civil case Davis v. Guam, the Ninth Circuit ruled that the Guam plebiscite law, which restricted voting in a political status plebiscite to only the native inhabitants of Guam, violated the 15th Amendment. The court held that the law employed an impermissible racial classification, finding that the definition of native inhabitants of Guam was a racial classification by using ancestry as a proxy for race. Thus, the court affirmed the ruling of the Guam District Court in favor of the plaintiff, Arnold Dave Davis. The central issue in this case revolved around the legality of Public Law 25-106, commonly known as the Plebiscite Law, which restricted voting in Guam's political status plebiscite to individuals characterized as native inhabitants of Guam. The question before the court was whether the provisions of that law restricting voting to native inhabitants of Guam constitutes an impermissible racial classification in violation of the 15th Amendment. In other words, is the native inhabitants of Guam a racial definition? Guahusi Pulan and Davis v. Guam was a case directly addressing CHamoru self-determination, and the ruling subsequently restricted the legal avenues through which Guam could express CHamoru self-determination. I will explain the Davis v. Guam case through delving into its historical and political context, legal proceedings, arguments presented by the plaintiff and defendant, and explaining the rationale behind the court's ruling. Throughout the course of Guam's history, its native inhabitants have been unable to exercise the right to determine their own political status. Spain colonized Guam in the late 17th century and maintained control over the island until the end of the Spanish-American War. Following the war, the 1898 Treaty of Paris gave Guam to the United States, and Article 9 of the treaty left the civil rights and political status of the native inhabitants of Guam to be determined by the U.S. Congress. Through a series of U.S. Supreme Court cases recognized as the insular cases, the doctrine of territorial incorporation was established. This enabled the United States to retain Guam indefinitely without affording the territory any avenue for self-determination, achieved by designating Guam as an unincorporated territory. Guam was under the control of the U.S. Navy from 1899 to 1950, with the exception of a period of Japanese occupation during World War II. In 1946, the United States voluntarily placed Guam on the United Nations list of non-self-governing territories. As a non-self-governing territory, international law dictates that the people of Guam have the human rights of self-determination and the end of its colonial status. As the administering power of Guam, the U.S. has an international obligation to assist the people of Guam in fulfilling their rights of self-determination. Throughout the colonial period, Guam's population consisted mostly of an indigenous people known as the Chamorros, who lacked self-government under either Spain or U.S. control. The 1940 census showed that the Guam's indigenous population, the Chamorros, constituted a supermajority of 91%. However, due to the United States' control over Guam's immigration policy, thousands of people were allowed to settle on Guam, and within the following decade, the Chamorro population had decreased to less than half of the total population. According to the 1950 census, Chamorros constituted only 45% of Guam's population. This intense shift occurred without the consent or choice of the Chamorros themselves. In 1950, Congress passed the Organic Act of Guam, which granted Guam limited self-government and extended U.S. citizenship to three groups: individuals born before April 11, 1899, who lived in Guam on that date as Spanish subjects and who continued to reside in some parts of the United States thereafter; individuals born in Guam before April 11, 1899, who lived in Guam on that date and who continued to reside in some part of the United States thereafter; and individuals born in Guam on or after April 11, 1899. The date, April 11, 1899, was selected because it marked when the 1898 Treaty of Paris became effective. In 1952, the Immigration and Nationality Act, INA, was enacted by Congress, which replaced the legal basis on which the inhabitants of Guam received U.S. citizenship, from the Guam Organic Act to the INA. From the 1980s onward, Guam actively pursued a change in political status with the United States. This effort reached the pinnacle in 1982 when the people of Guam, through a political status plebiscite and runoff open to all eligible voters, chose Commonwealth status. Subsequently, Guam drafted the Commonwealth Act, and attempts were made to secure its passage by Congress in the late 1980s and 90s. Despite these efforts, the Commonwealth Act failed to gain congressional approval, leaving Guam in its existing political status as an unincorporated territory of the United States. In 1997, the Guam legislature passed an act establishing the Commission on Decolonization for the Implementation and Exercise of CHamoru Self-Determination. The motivating factors behind the bill was that it had been almost 9 years since the people of Guam had transmitted the draft Commonwealth Act to the federal government, and that Section 102A, the CHamoru Self-Determination provision, has been significantly changed to warrant rejection of this section of the document. The general purpose of the Commission on Decolonization is to ascertain the desire of the CHamoru people of Guam as to their future political relationship with the United States, which would be accomplished through the Guam Election Commission conducting a political status plebiscite with participation restricted to the CHamoru people of Guam. The CHamoru people of Guam defined as all inhabitants of Guam in 1898 and their descendants who have taken no affirmative steps to preserve or acquire foreign nationality. The plebiscite would ask a single question: in recognition of your right to self-determination, which of the following political status option do you favor? Independence, free association, or statehood? Before the political plebiscite could have occurred in February of 2000, the Supreme Court in the case Rice v. Cayetano, finding that ancestry can be a proxy for race, struck down a Hawaii law that restricted the individuals eligible to vote in the election for office of Hawaiian Affairs OHA trustees exclusively to Hawaiians because the law employed an impermissible race-based classification, concluding that Hawaiians was a racial classification using ancestry as a proxy for race. The Hawaiian definition consisted of two subgroups within the Hawaiian citizenry. The smaller subgroup, referred to as Native Hawaiians, comprises any descendants of not less than 1/2 parts of the races inhabiting the Hawaiian Islands previous to 1778. The larger subgroup, known simply as Hawaiians, included descendants of peoples inhabiting the Hawaiian Islands in 1778. Petitioner Harold Freddie Rice, a U.S. citizen and resident of Hawaii, attempted to register for the OHA trustee election, but he was denied because under the Hawaiian definition, he did not have the required ancestry to qualify to vote in the OHA trustee election. Hawaii argued that the law is not a racial category at all, but instead a classification limited to those whose ancestors were in Hawaii at a particular time, regardless of their race. In support of this argument, Hawaii claimed that some inhabitants of Hawaii in 1778 may have migrated from the Marquesas Islands, the Pacific Northwest, and Tahiti. The restriction in its operation excludes a person whose traceable ancestors were exclusively Polynesian if none of those ancestors resided in Hawaii in 1778. And the vote would be granted to a person who could trace, say, 1/64 of his or her ancestry to a Hawaiian inhabitant on the pivotal date. The Supreme Court rejected Hawaii's argument that the classification is not racial in nature, holding that ancestry can be a proxy for race. In finding that Hawaii has used ancestry as a racial definition and for a racial purpose, the court noted that the very object of the statutory definition in question and of its earlier congressional counterpart in the Hawaiian Homes Commission Act is to treat the early Hawaiians as a distinct people. This Supreme Court decision brought great legal concern to Guam's 1997 plebiscite law because the restriction of the plebiscite to only Chamorus of Guam greatly paralleled the definition of Hawaiian that Rice v. Cayetano ruled as an impermissible racial classification by using ancestry as a proxy for race. Consequently, a month after Rice was decided in April of 2000, the Guam legislature replaced the earlier law with Public Law 25-106, referred to as the 2000 plebiscite law, which is at issue here. The law changed the persons eligible to vote in a political plebiscite from CHamoru people of Guam to Native Inhabitants of Guam, defined as those persons who became U.S. citizens by virtue of the authority and enactments of the 1950 Guam Organic Act and descendants of those persons. The law defined Native Inhabitants of Guam by reference to a category that originated with an act of Congress, the 1950 Organic Act of Guam. Descendant is defined as a person who has proceeded by birth from any native inhabitant of Guam, and who is considered placed in a line of succession from such ancestor, where such succession is by virtue of blood relations. The legal change of CHamoru's of Guam to Native Inhabitants of Guam was to distinguish the Guam's plebiscite law compared to the Hawaii law, on the basis that the voter qualification here is tethered not to presence in the territory at a particular date, as was the case for the definition of Hawaiian, but to the passage of a specific congressional law, the Organic Act, which altered the legal status of the group to which ancestry is linked. The purpose of the 2000 plebiscite law is to permit the native inhabitants of Guam to exercise the inalienable right to self-determination of their political relationship with the United States. In enacting the plebiscite law, the Guam legislature recognized that this inalienable right to self-determination had never been afforded the native inhabitants of Guam, its native inhabitants, and land, having themselves been overtaken by Spain and then ceded by Spain to the United States of America during the time of war without any consultation with the native inhabitants of Guam. The legislature explicitly denied any racial motivation. The intents of the law shall not be construed nor implemented by the government officials effectuating its provisions to be race-based, but founded upon the classification of persons as defined by the U.S. Congress in the 1950 Guam Organic Act. In 2004, the legislature enacted Public Law 27106, which required a 70% registration of the native inhabitants of Guam in order for the plebiscite to commence. It must be noted that the plebiscite is non-binding, meaning that its results have no legal effect and do not require Guam to adopt any official or desired political relationship with the United States. The only direct consequence is that the Commission on Decolonization shall promptly transmit the results of the plebiscite to the President and the Congress of the United States of America and to the Secretary General of the United Nations. Now that you understand the historical and legal context, we can move on to the legal proceedings. The plaintiff, Arnold Dave Davis, a white male, non-CHamoru U.S. citizen and resident of Guam, attempted to register as a voter in the plebiscite. However, he was denied registration because he did not meet the definition of native inhabitants of Guam. Consequently, on November 22, 2011, Davis filed suit in the District Court of Guam, challenging the 2000 plebiscite law on grounds that it violated the 5th, 14th, and 15th Amendments of the U.S. Constitution, the Voting Rights Act of 1965, and the 1950 Guam Organic Act. In the complaint, he claims racial discrimination in the voting process by Guam and alleges that the law prohibits him from participating on the basis of his race. Davis sought the court to enjoin the relevant provisions of the 2000 plebiscite law. The defendants, Guam et al., moved to dismiss the complaint for lack of standing, arguing that there was no justiciable case or controversy because Davis had suffered no injury, since there was no set date for when the plebiscite will occur, nor real threats of the plebiscite occurring anytime soon, since the 70% registration requirement of native inhabitants of Guam was not close to being met. For federal courts to even take up cases, they require Article 3 standing, which is the legal concept that requires the plaintiff to demonstrate an injury in fact caused by the defendant and redressable by court order. The injury must be concrete and particularized, not conjectural or hypothetical. Furthermore, it was argued that Davis lacked ripeness. The legal principle of ripeness pertains to the timing of judicial intervention, aiming to prevent federal courts from becoming involved in abstract disputes by adjudicating matters prematurely. A claim might be deemed unripe if it relies on anticipated future events that may not transpire as predicted or may not occur at all. If postponing a case's decision would enhance the court's ability to resolve the dispute, particularly when additional factual information would aid in adjudication, the case may be considered unripe and consequently non-judiciable. On January 9, 2013, Judge Tydinko Gatewood dismissed the case for lack of standing and ripeness grounds. Davis appealed to the Ninth Circuit, and on May 8, 2015, in a 2-1 decision, the Ninth Circuit reversed the district court and found that the case had standing and was ripe for review. The court only ruled on the standing issue and not the merits of the case. According to the majority opinion authored by Judge Alex Kozinski, relying on the Supreme Court ruling in Heckler v. Matthews, Davis had standing because the 2000 plebiscite law provided unequal treatment in voting, which is a type of personal injury the Supreme Court has long recognized as judicially cognizable. The court bound Guam's argument that the plebiscite was only a non-binding symbolic vote, in contrary to Matthews, which held that unequal treatment is an injury even if curing the inequality has no tangible consequences. The court also found that Guam understated the effect of any plebiscite, which would require officials to transmit the results to the President, Congress, and the United Nations, thereby taking a public stance, and making it more likely that Guam's relationship to the United States would be altered to conform on that preferred outcome. The court further held that Davis's claim was ripe because he was currently being denied equal treatment under Guam law. By being excluded from the registration process, Davis claims he is unlawfully denied a right currently enjoyed by others. The dissents written by Judge N.R. Smith argued that the majority misapplied Matthews to conclude that Davis had standing, which was not based on voting rights cases, but based on one's ability to seek Social Security benefits. To Judge Smith, the injury alleged by Davis is merely being denied the right to register to participate in what he viewed as an opinion poll that will likely never occur. Supporting his view with numerous court precedents, Judge Smith concludes the case lacked ripeness because the alleged injury is too remote and abstract, as there is no scheduled dates for the plebiscites and that the plebiscite is likely to never occur. Now having standing, Davis refiled his suit in the District Court of Guam, challenging the 2000 plebiscite law on grounds that it violated the 5th, 14th, and 15th Amendments of the U.S. Constitution, the Voting Rights Act of 1965, and the 1950 Guam Organic Act. The case was heard in Guam's District Court on September 1, 2016. The court found that Native Inhabitants of Guam was a racial classification by using ancestry as a proxy for race in violation of the 15th Amendment's prohibition of racial discrimination. And the way that the court found that Native Inhabitants of Guam was a racial classification was by applying the precedents of Rice v. Cayetano's finding that ancestry can be a proxy for race. Guam argued that the relevant provision of the plebiscite law, which restricted voting to Native Inhabitants of Guam, was not in violation of the 15th Amendment for the following reasons. First, the 2000 plebiscite law was not motivated by racial discrimination because the definition of Native Inhabitants of Guam is a political classification, referring to a colonized people with a unique political relationship to the United States because their U.S. citizenship was granted by the Guam Organic Act, rather than a racial classification, as the Native Inhabitants of Guam definition included everyone on Guam who was affected by the 1950 Organic Act citizenship, and not exclusively to CHamoru's. Guam supported their non-racial argument by pointing to the 1950 census for Guam, which confirms that there were multiple racial or ethnic groups that became U.S. citizens by virtue of the Organic Act. It was not limited to one racial group, such as CHamoru's. Guam sought to differentiate this case from Rice v. Cayetano by asserting that the voting qualification is not linked to presence in the territory at a specific date, as was the scenario defining Hawaiian. Instead, it is tethered to the enactment of a specific law, the Organic Act, an act of Congress which modified the legal status of the group associated with the ancestry. Furthermore, Guam pointed to the provisions of the Plebiscite Law which explicitly denies racial intent. The intent of this chapter shall not be construed nor implemented by the government officials effectuating its provisions to be race-based, but founded upon the classification of persons as defined by the U.S. Congress in the 1950 Organic Act of Guam. Second, the plebiscite is not an election within the meaning of the 15th Amendment because no public official will be elected, nor will any issue of state law or policy be decided. The plebiscite vote was symbolic and not an election, as it was only to gauge the views of the native inhabitants of Guam as to their future political relationship with the United States. Its results have no legal effect and do not require Guam to adopt any official or desired political relationship with the United States. The only direct consequence is that the Commission on Decolonization shall promptly transmit the results of the plebiscite to the President and the Congress of the United States of America and to the Secretary General of the United Nations. Third, the fundamental right to vote guaranteed under the 15th Amendment applied differently to Guam because of Guam's unincorporated territorial status. Guam supported this argument by pointing to the insular cases, which established that the U.S. Constitution does not apply in full to unincorporated territories. Guam also argued that the plebiscite should only be for the native inhabitants of Guam because they are the colonized people who have the right to self-determination, and that by limiting the plebiscite to the native inhabitants of Guam would allow for the United States to uphold its international obligations to the native inhabitants as colonized people. In the judgment issued by Judge Tydinko Gatewood, the court did not find the arguments made by Guam to be persuasive. The court held that the Guam law on voter qualification for the plebiscite violates the 15th Amendment's prohibition of racial discrimination, finding that native inhabitants of Guam is a race-based classification by using ancestry as a proxy for race, and that the plebiscite is an election within the meaning of the 15th Amendment. Furthermore, the court found that the law violated the Equal Protection Clause of the 14th Amendment. Beginning with the 15th Amendment, the court applied Rice v. Cayetano and concluded that Guam's voting restriction to only native inhabitants of Guam used ancestry as a proxy for race in part because it excludes nearly all persons whose ancestors are not of a particular race. Even an adopted child of a descendant cannot vote in the plebiscite. Bloodline/ancestry is required. The court concluded that the specific sequence of events leading to the 2000 plebiscite law made clear that the restriction is race-based and had a discriminatory purpose, citing its history as well as statements by lawmakers and others confirming that the plebiscite law secures a CHamoru only vote. For example, a month after the ruling of Rice v. Cayetano, the 2000 plebiscite law in question was passed, which changed the previous law which restricted persons eligible to participate in a political plebiscite from CHamoru's on Guam to native inhabitants of Guam. Furthermore, the native inhabitants of Guam definition mirrored the definition of CHamoru for qualification in the CHamoru Land Trust, and so on. The court rejected Guam's argument that the plebiscite was outside the 15th Amendment and held that the plebiscite qualified as an election within the meaning of the 15th Amendment. The court primarily relied on the case Terry v. Adams, where the Supreme Court has held that the 15th Amendment includes any election in which public issues are decided or public officials selected. In the case of Davis v. Guam, the public issue is ascertaining the future political relationship of Guam to the United States. This public issue affects not just the native inhabitants of Guam, but rather the entire people of Guam. Every Guam resident otherwise qualified to vote can claim a profound interest in the outcome of the plebiscite. Furthermore, the results of the plebiscite will be transmitted to the President and Congress, as well as to the United Nations, which the court considered a significant enough consequence. The court found Guam's argument that the right to vote under the 15th Amendment is not applied the same in the unincorporated territory to be incorrect. While it is true that the U.S. Constitution may not fully apply in unincorporated territories, Congress has explicitly extended the 15th Amendment and the Equal Protection Clause of the 14th Amendment to Guam when it enacted the Organic Act of Guam. Accordingly, Guam's use of the Insular Cases Doctrine to support their arguments in this case fails. The court then ruled that Guam's racial restriction did not withstand strict scrutiny as per the 14th Amendment. Strict scrutiny, the most rigorous form of judicial review, applied to assess the constitutionality of laws infringing on fundamental constitutional rights or suspect classifications, required that the government prove the law's necessity to fulfill a compelling state interest. Additionally, the government must demonstrate that the law is narrowly tailored to achieve that compelling purpose, and that it utilizes the least restrictive means to reach its objective. Failure to meet these criteria results in deeming the law unconstitutional. Guam, in this case, failed to demonstrate that its method of achieving its goal is narrowly tailored, especially given the existence of other alternatives for gauging the preference of the colonized people, such as conducting a poll with the assistance of the University of Guam. The court also found that Guam's international law arguments concerning the United States' international obligations to the native inhabitants as colonized people in no way allows for this court to disregard or circumvent the U.S. Constitution and the laws of the United States so that the plebiscite can proceed despite the racial classification. Based on all these reasons, on March 8, 2017, the District Court of Guam found that the plebiscite statute impermissibly imposes race-based restrictions on the voting rights of non-native inhabitants of Guam in violation of the 15th Amendment. The court also found it violated the 14th Amendment, and as a result of the ruling, the plebiscite law restricting the vote to native inhabitants of Guam was struck down. Guam appealed to the Ninth Circuit, and on July 29, 2019, the Ninth Circuit held that the Guam plebiscite law violated the 15th Amendment and affirmed the district court's ruling, basing its entire decision on the 15th Amendment. Similar to the district court, the Ninth Circuit concluded that the plebiscite constituted a vote under the 15th Amendment. The Ninth Circuit relied primarily on Terry v. Adams and Rice v. Cayetano and extrapolated a rule that the amendment includes any government-held election in which the results commit a government to a particular course of action. While the court acknowledged that Guam's plebiscite will not itself create any change in the political status of the territory and will have only limited immediate impact by obligating Guam to transmit the results of the plebiscite, it decided that this consequence was significant enough to make the political status plebiscite a vote. The Ninth Circuit then concluded that the 2000 plebiscite law, although facially neutral, impermissibly used native inhabitants of Guam as a proxy for race. The court dismissed Guam's arguments that native inhabitants of Guam is fundamentally a political classification rooted in an act of Congress, not an ancestry or race-based status. The court made no judgments about whether Guam's targeted interest in the self-determination of its indigenous people is genuine or compelling. The court thought this inquiry irrelevant because established 15th Amendment principles which single out voting restrictions based on race as impermissible, whatever their justification. Guam appealed to the highest court, the Supreme Court. However, the court denied cert. The Davis v. Guam decision exemplifies the clash between the American legal system and CHamoru self-determination. Guam views that CHamoru, or native inhabitants of Guam, have the right of self-determination as guaranteed by international law because they are the colonized people who never had the chance to even express that right and who have a unique relationship with the land, while the U.S. views it as a domestic issue of racial discrimination. The irony here is evident. The United States, having colonized Guam and maintained its colonial status using racial discriminatory legal reasoning from the insular cases, historically denied Chamorus their right to self-determination, manipulated Guam's immigration policy to render Chamorus a minority in their own land, and then paradoxically invoked the principle of equality to reject CHamoru's self-determination in Davis v. Guam. If you liked and enjoyed the video, consider supporting me on Patreon so I can continue to produce more Pacific Studies content. Like this video, subscribe to the channel, and turn on all notifications. Follow me on social media at PulanSpeaks. And a special Seduce Masi to Patreon supporters Puti'on, Dylan Sablan, and Jesse Babauta. Seduce Masi for watching, Guahu si Pulan, and Pulan has spoken. Esta.